Yes, it's fine.
You should have on your bench a small file of documents dealing with those matters your lordships and your ladyship asked about this morning. Sorry to burden you with more documents, but I hope...
No, the fault is mine.
Pretty quick work, isn't it?
I have to thank Mr. Bunting's clerks. They were including an index, so that's really, really very, very grateful to them.
Where physically does he do this, actually? I'd be interested. I'm just interested to know.
Well, they raced back to Chambers
Did I see?
and ran, and got somebody to type them on their mobile phone up there probably, and then ran all the way back probably. So anyway, so I am very grateful. Anyway, dealing with those matters your lordships and your ladyship asked about this morning. First of all, can I just deal with the explanatory notes, starting with tab 6. And you'll see that under the summary, paragraph 5 in particular, deals with the fact that these are reforms, so these aren't consolidating provisions. That Act, that was the 1988 Act, was a consolidation of existing legislation. In replacing the Act, this part produces new concepts, a few new concepts, and so on, and then goes through each of the matters. And then, again, just in terms of perhaps changes, we see, or purpose, at paragraph 14 over the page. Purpose of the Act is to establish more effective, transparent and responsive justice, and so on. That's a mixture of things because it also involves sentencing changes, but we can see too that it covers matters concerned with the inquests.
Yes, I was... The end of paragraph 5 refers to the imposition of the duty to conduct and investigation, which is seen as broader than the previous law. Thank you.
And then 7 is the explanatory notes, or explanatory memorandum to the 2013 regulations. Those are the investigation regulations. And if you turn to 2 pages from the back to the explanatory note, I think, my Lord, this is what you had in mind earlier, my Lord Reid.
Yes, I did. It is.
So introduced a new regime. You see that in paragraph, the second paragraph. And then the rules. Oh, yes. Sorry, I ought to have said this. So the same explanatory note, the last paragraphs, these regulations form part of a package of new rules and regulations made under the 2009 Act. Thank you. Which come into force at the same time and refer to the rules in terms there. Regulating practice and procedure. And then at tab 8, the explanatory memorandum to the rules, making clear they're under section 45 and that there have been a number of changes. And over the page dealing with the policy background, and again in making clear that there are specific policy objectives, underpinning the decision to introduce legislation. And then the rules, 7.2, rules are drafted with these intentions in mind, update relevant provisions, putting particular emphasis on providing better information to bereaved relatives, including a new requirement to disclose documents, clarify the position in relation to evidence, etc. And then new rules also update the terminology of the old 1984 rules to reflect the Act, with the coroner or jury making determinations and findings at the end of an inquest rather than verdicts, and completing the record of the inquest rather than the inquisition. Again, referring in terms to the record and...
So that's really the emphasis on clarifying the current provisions, not changing anything.
Well, yes, except providing a, I suppose, more systematic way for recording.
Yes,
some.
but I think it confirms what comes out of the guidance referred to by the Court of Appeal, that the intention of the footnote was to record what was thought to be the existing case law.
Yes. What was thought to be existing case law, yes, yes. That leaves K&K and warning. K&K, as of course my Lord Reid knows, concerns changes made to various cost provisions. You'll find K&K behind tab 1. And just in very short summary, and I hope I understood this fully, the issue was whether or not interest on costs was payable from the date of the costs order or from the date of taxation. There had been a note in a statute introduced pursuant to the Supreme Court Act, which indicated how interest was to be calculated or from what date. That note, that footnote, was removed, and so the question was, firstly, did the footnote have any significance, and therefore was its removal significant? And of course the relevance of it here is we're in footnote territory 2, and the fact that it's a footnote does not mean it doesn't have legal effect. It is the principle to be drawn from this.
And it was a footnote to a form, I think.
Footnote to a form, they were indeed, my lord, footnotes to a form, yes.
But 48G to H, Lord Denning's judgment, although one note was scrapped, there was a previous note, and the question is whether one went back to that. And he thought you could. We can go back to the note which appeared in the statute of 1875. Alternatively, we're entitled to say the rule of equity should prevail. In the further alternative, we're entitled to apply a little common sense. So, arguably, Miss Monaghan, he didn't pay all that much respect for the note to the statute in 1875.
Well, no, but he does. I mean, well, he assumes that one reverts to the note that's supposedly been replaced.
And Lord
by
Justice
a note that's
Stevenson doesn't agree with it.
Precisely.
And then Lord Justice Orr agrees with them both.
Yes, yes. But perhaps it can be put like this. Certainly it's understood that the note or notes have some significance. Quite what the significance in their contexts, there's not unanimity about, but it has some legal force.
Okay.
It's not a scribble by the draftsman at the end of a document to make it look neat.
No.
And the warning case is simply applies K and K. For material purposes, simply applies K and K.
What was the note there?
What was the note?
What was the note in warning?
The same one, I beg
That
your
was the same
pardon. It's
note, right.
exactly the same point.
I'm sorry, yeah.
I ought to say that you've got one other case in your bundle. I don't want to make things even more complicated for myself, but behind tab 3 is Hunt. I don't know if your lordship's familiar with it, but Hunt indicated that K and K and warning were wrong. Your ladyship's familiar with it, but only because, in fact, what they said was the change in the note was attributable to the fact that the structure of the form had changed, so the note had simply been embraced in the form itself rather than as a footnote, so it didn't alter the effect. And we only put that in there in case when your lordships were reading, you're well ahead of me, I can see, but we thought perhaps you might read and then discover, well, hold on, they've just spoken to 2 cases and they've all been repealed.
So did this judgment of the House of Lords, what significance did the House of Lords attach to the footnote to the form?
Sorry, I'm not sure I heard that one.
Oh, I'm wondering what significance the House of Lords attached to the footnote to the form.
Did you tell me this?
one suspects he might have attached rather more significance to it than Lord Denning had.
You did. Hold on. Let me.
I think it had gone, hadn't it?
Right. Paragraph. I'm very grateful to Mr. Bunting. Page 415E. They were proving cases that previously identified with them. They are approving Pyman. So, in other words, those were the cases that indicated that the notes had significance, which were referred to in K and K, but simply observed that K and K misapprehended the nature of the amendment.
Yep. Mm-hmm. And I think you've given us, I think, also the passage from Benyon.
Benyon is at the last tab, tab 9. It's not in its normal hardback lovely form because it's off a printer, but it's exactly the same content. And if you look over the page, page 2, footnotes, if material is put into the form of a footnote, it is still fully part of the Act and must be construed accordingly. Cites warning that position.
We may have to look at these authorities and ask ourselves, footnote to what exactly?
Well, footnote to the Act, we're in the sphere of subordinate legislation here. It seems unlikely that there would be any distinction. We have an appended form which coroners are told must be used, it's mandatory. And there is a note to that form, which even if it were in primary legislation would be binding. No reason why it's in the context of a form which is particularly prescribed to deal with the matters that are the subject of the rules. No reason we say why distinction should be drawn.
I mean, the argument against you is that this is simply a narration of an understanding of earlier case law which this court can depart from. I suppose as against that, one would say if footnote 3 were a substantive rule here, one wouldn't be discounting it because it reflected the previous law. One would say, well, that's the rule, that's that. Yeah. Does it make a difference? Does it make a difference that the two sentences appear in a footnote rather than in a rule? Precisely.
And let's assume for the moment, I don't say this, but let's assume for the moment that there was a misunderstanding about what the law was because the authorities weren't properly read. Well, in my respectful submission, that's nothing to the point. That's a legislative change, not a matter with respect this court has power to do anything about as matters are.
Well, if it were in the body of the regulation and it were a narrative of previous cases, that would be taken, would it not, to be an endorsement by the regulatory power of that legislation. And I assume your argument would be the happenstance that it is contained in a footnote can't rob it of the same significance as if it were in the body of the regulation itself.
Yes. I mean, that was the point in Hunt. I mean, slightly different point, but the point was not that the footnote didn't carry weight, but simply when they moved it into the form itself, it carried the same weight. I mean, it made no difference that it was in a footnote as opposed to the structure of the form. It carried the same legal weight. And as I've indicated, as my Lord has indicated, and I was endeavouring to suggest, even if whoever drafted this misunderstood all the case law, I don't say they did, but even if they did, that's a matter for the legislature to sort out.
Well, I mean, I'm interested by that. For the moment, myself, I'm not convinced that it's as simple as that. Because if it's clear that this is simply there to reflect the existing case law, and we say the existing case law was wrong, I'm not sure why we're stuck with the note. I mean, obviously, these other cases, they all depend on their own context, but we've got to construe this note in its context with a bit of common sense, as Lord Denning said.
Well,
We then might get into the case law about reviewability of statutory instruments. I mean, effectively, one's saying, I think, on that footing, that there's an error of law in the making of the statutory instrument.
Yeah.
And there is no error of law in the making of the statutory instrument. Is that what your lordship's point?
Well, I'm wondering if
Well,
that's really...
all I'm
sorry, I beg
saying,
your
I
pardon.
mean, I hope we don't have to go down.
No.
But I'm saying, that for my part, I don't think it's as simple as that.
Well, it's not, nobody's suggested it's ultra vires, so it falls within the scope of the enabling powers. Whatever caused the draftsman to include it, whatever caused it, they could, whether it was previous case law, whether it was a completely fresh decision to...
And I understand the argument that way, but I also think there are arguments the other way, but I'm not sure whether there's anyone here who's going to be interested in articulating them.
Probably not me, my lord.
No, exactly. I'm not. But we also have the problem that it doesn't apply to narrative. And of course, in this case, it was a narrative verdict. So where does it get you?
Well,
I know you say well, it ought to be the same, but the regulation treats them as different.
Well,
Footnote treats them.
as was explored earlier on, it would be our submission that if it's a suicide...
Oh, no, I
doesn't
understand
lose
your submission, but it's not what the note says.
Well, the narrative as fits comfortably with the amendments made to Section 5, or sorry, the introduction of Section 5.2, which allowed for the circumstances to be taken into account so that they can form part, understanding that that would form part of a narrative, because plainly it would fall outside a short form, like the prison officer didn't. I don't say that happened here, by the way, I should make it clear. I don't say that happened here. But in a
Yes. I mean, you say
example case, it's didn't do its duty or whatever.
You know, if I've got this right, you say that since the form provides for a criminal standard of proof for the short form conclusions of unlawful killing and suicide, it follows that you can't have a narrative conclusion which amounts to either of those two verdicts, because that would be inconsistent with what's clearly the intention of the legislature.
Yeah.
And so it follows from that that if you were going to bring in a verdict of suicide, you would have to use the short form conclusion, but you could add to it a narrative to deal with the circumstances that had led to the suicide.
Precisely, my lord, precisely. And so it gave effect to Middleton and the Article 2 obligation. That's all my submissions except for one point that my Lord Wilson raised, and that was on our case. You asked, at paragraph 55, do we allied the seriousness and heightened scrutiny test, having said that we didn't.
I think that was what I was accusing you of. Was it fair?
I would say no, my lord.
No.
I would say it's a little more nuanced than that, but probably could have been clearer. So at 55, secondly, a suicide conclusion can have very serious consequences for the reputation of the deceased and surviving family. And then it goes to inherent probability. And we know that inherent probability is something that can be taken into account. So it's simply saying it's not the seriousness of the outcome that requires a heightened standard. It's the improbability of an act taking place that is a factor to take into account in deciding on the cogency of the evidence required. So I'd describe it as a nuance, but perhaps we could have put it clearer. But I hope it's not entirely inconsistent with everything I've said this morning. My lords and my lady, that's everything I have to say, subject to any questions from the court.
Well, thank you very much, Ms. Monaghan. Mr. Bunting, do you follow? Yes, Mr. Huff.
My lords, my lady, as you're aware, the Chief Coroner of England and Wales, for whom I appear, is a leadership judge with responsibilities for the coroner service. In this case, he has taken an exceptional step of intervening. He has done so because of the general importance of the issues raised, both to coroners and to those involved in inquests, notably bereaved families. His position is entirely non-partisan. He doesn't positively advocate any particular outcome. His concern is that the law should be clear and accessible for coroners so that inquest practice is consistent and unnecessary legal disputes are avoided. As we indicated in our application to intervene, the purposes are threefold. First, to assist the court on the background to the conclusions of suicide and unlawful killing, and on the interplay between short form and narrative conclusions. Secondly, to explain coronial law, practice and procedure, and to address the implications of the decisions this court may reach. And thirdly, to ensure that the court has received full argument for and against each realistically possible answer. Subject to my lords and my lady, I propose to make my submissions in 7 parts. First of all, some general submissions on the legal regime governing coroners and inquests, focusing on inquest determinations. Secondly, standards of proof in civil proceedings. Thirdly, the suicide conclusion in inquests. Fourthly, the unlawful killing conclusion in inquests. Fifthly, arguments in favour of the civil standard applying to findings of suicide. Sixthly, arguments in favour of the criminal standard applying to findings of suicide. And seventhly, finally, the standard of proof for unlawful killing and why that conclusion may justify the criminal standard, whatever is decided concerning suicide. May I turn then to the first topic, the legal regime governing inquests. As my lords and my lady have seen from both the appellant's case and ours, the office of coroner has a millennium of history and its role has developed over the centuries. It was the Coroners Act of 1887, which we shall look at briefly later, that laid the statutory framework for coroners to investigate the causes and circumstances of unnatural deaths and deaths of unknown cause. Further statutory changes were made piecemeal over the 20th century, promoted in some cases by the Wright Report of 1936 and the Broderick Report of 1966. Consolidating legislation, and it was consolidating legislation, was introduced in the form of the Coroners Act 1988. After the Fundamental Review of Death Certification and Investigation and the Shipman Report, both around 2003, there was a further process of legislative reform which produced the present governing legislation, the 2009 Act, the Coroner's Inquest Rules 2013, and the Coroner's Investigations Regulations 2013. And to pick up a point which my Lord Carnwath made, and which I'll address in a little more detail later, the package substantially reproduced the previous regime while building upon it in various respects. And in particular, when it came to determinations, it substantially reproduced the previous regime.
This is a 2013.
The 2009 Act, which was brought into force with the rules and regulations in 2013. In arguing for the criminal standard of proof to apply to suicide conclusions, the appellant's case naturally stresses some historical features of the coroner's role which touched on criminal justice. And we, of course, acknowledge those features. But the coroner service today is a death investigation service which is primarily concerned with establishing the causes and circumstances of deaths as matters of fact. And I will keep stressing factual and matters of fact. In most respects, it is quite distinct from the criminal justice system. With those points by way of preliminary, may I turn then to the Coroners and Justice Act 2009. Before going to the Act, may I look briefly at the explanatory notes, which Ms. Monaghan took you to a few moments ago. They're at divider 6 of the new file. And I was going to advert to the part of paragraph 5 which was addressed in the exchange between Ms. Monaghan and Lord Carnwath. This is on page 382 at the top right. In the last couple of sentences, the author points out that a new concept of investigations has been produced. but that was to recognise work which had been unrecognised in the 1988 Act, but which happened anyway. It wasn't creating an entirely new function for coroners. The previous Act spoke of and regulated inquests. The new Act brought the statute into line with reality, where there was a broader
I see the word. Lord Chief Justice Lane was talking about investigation back in 1982.
Exactly.
So it's an old concept, but formulated in the statute for the first time.
Exactly. What the statute sought to do was recognise that an inquest hearing is only part of a broader investigation.
Yeah.
And as will be seen from that note, the part of the Act concerned with coroners was introducing a few new concepts rather than introducing an entirely new regime. May I then turn to the Act, and I can do so relatively briefly because of Ms. Monaghan's comprehensive coverage. It begins at MS 809, Authorities 1.1. And Section 1 contains the duty to investigate deaths in terms which are substantially the same as the pre-existing regime. Section 4 at MS 811 contains the procedure by which an investigation can be concluded without the need for an inquest hearing if the cause of death is revealed by a post-mortem examination and an inquest is unnecessary. Again, that had an analogue in the 1988 Act also. In the absence of the use of that Section 4 procedure, there will usually be an inquest. I say usually because there are some circumstances, such as after a criminal trial, that a coroner can open an inquest, adjourn it and not resume it on the basis that resumption is unnecessary. Section 5 of the Act at MS 812 deals with the matters to be ascertained, identifying the objectives of a coroner's inquest as being primarily, Section 5.1a to b, to ascertain the answers to 4 factual questions: who the deceased was, and how, when and where he or she came by his or her death. As we'll see, those 4 factual questions date back to the 1887 Act. And 5.1c, the inquest should also provide the formal particulars required for registration of the death. Again, a matter going back to the 19th century legislation. You've been shown subsection 5.2, which gave statutory effect to the decision of the House of Lords in the Middleton case, but you haven't been pointed to section 5.3, which precludes the senior coroner or a jury expressing any opinion other than the matters set out previously in section 5. And that's subject to the coroner's power to make a prevention of future deaths report, with the word subject to paragraph 7 of Schedule 5. My Lords, then moving to section 7 at MS 814, you've been again shown this briefly. It's the section governing whether a jury is required, the starting point being that an inquest must be held without a jury, unless either section 2 or subsection 2 or subsection 3 applies. Subsection 2 identifies the mandatory grounds for summoning a jury, including cases of those who die in custody of a violent, unnatural or unknown cause. And then subsection 3 gives coroners a residual discretion to summon a jury where that is not mandatory. As is apparent from the statistics we quoted in our printed case, the vast majority of inquests are heard without juries, and that includes the vast majority of inquests in which suicide conclusions are considered, and even many inquests in which unlawful killing conclusions are considered. Now, this is a matter which has developed over time. In the 1887 Act, all inquests were to be held with juries. There was then a gradual relaxation and change as the statutes went by. Section 10 on MS 816 governs the determinations at the end of an inquest, with subsection 1 requiring a determination that answers the 4 questions of fact: who, when, where, how, and also findings providing the particulars for death registration. And section 10.2 is of importance, that a determination may not be framed in such a way as to appear to determine any question of criminal liability on the part of a named person or civil liability. Now, those provisions which mirror those of the previous legislative package aren't prescriptive about the form in which determinations are to be expressed. They simply say that a determination must answer the 4 factual questions, must then be findings as to the particulars of death for death registration, and they must not stray into the territory of appearing to determine criminal liability of a named person or civil liability. Section 10.2 is, of course, like the predecessor provision, worded in such a way as to preserve the unlawful killing conclusion. We'll look at that in a little more detail later. Can I then turn to the coroner's inquest's rules? These begin at MS 827, and I was going to pick them up with Rule 34, MS 841. As my lords and my ladies saw, this is the rule which does stipulate a form to be used in recording the determinations which answer the statutory questions. Ms. Maughan is quite right to say that the predecessor rules scheduled a form very similar, which was called an inquisition rather than a record of inquest, and which, but the predecessor rules stated, as my lords and my ladies saw, that rule could be used with such adaptations as were regarded as appropriate. This is a mandatory provision. May we then turn to the form at MS 846. Now, the previous rules of 1953 and 1984 had a similar form, which, as I say, was called an inquisition. The 4 questions of fact are answered by completing a number of sections, and the how question, which is, of course, the critical one, is answered by a combination of entries in 3 sections. Section 2, medical cause of death. Section 3, how, when...
Which page are we on now?
I'm sorry, MS 846, right at the end of tab 2 of Authorities 1.
Yeah.
So to answer the how question, coroner or jury gives a medical cause of death at entry 2. They then complete section 3, how, when and where, and in Article 2, cases in what circumstances the deceased came by his or her death, and then section 4, conclusion of the coroner or jury as to the death. Now, in section 3, the coroner or jury will usually write a sentence or 2 summarising the circumstances of death in brief, simple and neutral terms. Section 4 is for a short conclusion on how the person died, and as notes 1 and 2 correctly state, section 4 may be completed either with one of a number of short-form conclusions or a short narrative, or both.
Where do we find notes 1 and 2?
Note 1, little Roman 1, above all the big Roman numerals, one of the following short-form conclusions may be adopted.
What page is that, please?
Page 846, MS 846.
Halfway down the page.
Oh, yes.
Then little
You
Roman.
say there was something equivalent to this appended or in a schedule to the previous rules,
Yes.
can we see the immediately earlier form prior to these rules coming in?
It isn't in the bundles distinctly, but we're going to look shortly at a case called Jameson, which I think does quote from it.
Speaking for myself, unless it's too much of a burden, I'd like to see the form in the previous rules.
We'll get that.
Thank you.
The short form conclusions, which we see here listed, were developed in the 19th century. Before that, most verdicts in coroners' courts had been in narrative form. Over the Victorian era, coroners and juries took to giving short form verdicts using the words and phrases which were used in the annual return. So phrases such as natural causes, industrial disease, and so on. A list of short form verdicts in roughly this form was first produced officially in the Coroner's Rules of 1953. There's a fuller exposition of the history in the Chief Coroner's Guidance number 17, which is MS 2282, but I don't go to that. Using a short form verdict assists with the statistical reporting of deaths. Also, nowadays, any short form verdict will be included in a person's entry in the register of deaths after the inquest. That's a matter of convention rather than statutory requirement, but it is a matter of convention which is of considerable importance to bereaved families. That position is summarised in the Fraser case at MS 1173, but again, I don't need to go to that.
Note 2 expresses the brief narrative conclusion as an alternative or in addition to one
Yes.
of the short form conclusion. What would you say to the proposition that that suggests that it should not be inconsistent with a short form
I'd say that's right.
conclusion?
There is, as I was about to say, there is no magic in whether the question is answered by a short form or a narrative or a combination of the two.
Well, you want to come to 3 in a moment, aren't you?
I was going to come to 3 later. The short answer that we would make is that the rule-making power is broad enough to allow rules to stipulate standard of proof, but that this rule does not do so as a matter of statutory construction.
We'll come to that. I mean, I think it's quite useful the way you were taking us through the background of this.
Yes.
Myself.
Well, I was taking you through the background in order then to say what happens in practice, but it is important to see how the statutory provisions and the rules interlock. Now, it's always been open, even before Article 2 and Middleton, for a coroner or jury to give a short narrative conclusion in Section 4 of the Inquisition or Record of Inquest form. And if I may, in order to give this some colour, I'd like to take you to the case of ex parte Jameson, which was the governing case before Middleton and remains the governing case for the majority of cases, majority of inquests, where Article 2 is not engaged. That is Authorities 3, tab 44, MS 1505. Now, this is tragically another case of a man who hanged himself in prison. It was a verdict of suicide, and a fair amount of the case was concerned with the coroner's exclusion of an adjectival finding of neglect. From page 23, which is MS 1527, having set out the historical and statutory background, the Master of the Rolls gave a number of general conclusions. And at 23H, MS 1527, he began by saying that an inquest is a fact-finding inquiry conducted by a coroner, with or without a jury, to establish reliable answers to four important but limited factual questions. And a couple of sentences further down, he recognises that the how question is the normally critical question. If we go over the page to page 24, General Conclusion 2, he states that in the Act and the rules, the word how is to be read as meaning by what means the person came by their death, which is a more limited limited question even than how the deceased died. This authority, which reflects previous authorities, makes clear that the how question is to be interpreted as by what means the person came by their death, which is a question directed to the immediate means of death, rather than the underlying circumstances. General Conclusions 3 and 4 stress that the prohibition on conclusions appearing to determine the criminal liability of a named person or civil liability are important, but they have been framed in such a way as to legitimate a verdict of unlawful killing. That's it, just by letter C. At subparagraph 4, it's also said that the prohibition on determining criminal liability of a named person or civil liability is fortified by considerations of fairness, because in an inquest, unlike a trial, there isn't the same panoply of procedural safeguards for those whose interests are at stake. And at number 6, by letter F, Master of the Rolls recognises that even then there could be no objection to a verdict incorporating a brief, neutral, factual statement, as long as it wasn't judgmental in terms. So narrative verdicts of a kind were permissible before the Middleton case came along. Most of the remaining general propositions concern the adjectival conclusion of neglect, which we don't need to consider. So we can set aside Jameson. I'm afraid it doesn't contain a full recitation of the form. We will get the form for tomorrow.
Thank you.
The incorporation of the ECHR into domestic law resulted in changes to these principles for a minority of inquests in which state bodies or agents may have been responsible for the death.
Sorry, just before you go on, looking at subparagraph 6, there can be no objection to a verdict which incorporates a brief, neutral, factual statement, and then examples are given. Do you accept that in this case the statement was not neutral?
Absolutely. But that's because Middleton said that narrative verdicts under the Middleton regime don't need to be neutral. They can be judgmental, as was the sample verdict suggested by Lord Bingham in Middleton. It was not a neutral.
Of course, it depends what one means by judgmental in their context, but
yes.
we come back to that.
Yes, we shall. As my lords and my lady are well aware, the right to life enshrined in Article 2 has a procedural element, and one aspect of that element is a requirement on member states to establish independent investigations into deaths for which the state or its agents may bear responsibility. And those investigations have to comply with a series of standards, including public accessibility, efficacy, family involvement, and so on. And to comply with this requirement, a member state must establish a set of procedures. It isn't the case that one individual procedure will always or generally satisfy Article 2. after all, one aspect of the Article 2 procedural obligation is to enable those at fault to be brought to account and punished. An inquest can't do that. Most states have separate procedures for investigation, prosecution and punishment. And when the Strasbourg courts consider compliance with Article 2, they consider whether a state's procedures in the round achieve compliance. So when we look at the Middleton case, as we will in a moment, the critical question the House of Lords was considering was how can an inquest best play its part in satisfying the Article 2 obligation. May we then turn to the Middleton case, which is in the core volume of authorities, tab 6, MS 908. And I'll just pick up a few points which you weren't taken to by Ms. Monaghan, although she covered it very fully. May I begin with page MS 924, paragraph 20 towards the top of the page, answering the question he'd set himself as to what Article 2 required of a compliant investigation or of the inquest's part in a compliant procedure. At the end of paragraph 20, Lord Bingham said, to meet the procedural requirement of Article 2, an inquest ought ordinarily to culminate in an expression, however brief, of the jury's conclusion on the disputed factual issues at the heart of the case. So that's his critical benchmark standard for what Article 2 required. He then asks the question, does the regime for holding inquests established under the legislative package meet those requirements? And if we go to MS 927, after considering some of the cases, he provides the answer in the paragraphs my lords and my lady have already looked at, namely that in some cases, the existing regime for holding inquests will enable the jury to resolve the key factual issues, looking back to his benchmark test at paragraph 20. So where a choice between short-form verdicts with perhaps a non-judgmental narrative will allow the jury to resolve the critical question whether death was accidental or due to suicide, for example, then that will satisfy Article 2. But in some cases, Article 2 won't be satisfied, and that was the Middleton case, because the means of death was obvious to everybody. It was suicide. The disputed factual issue was whether the prison authorities had complied with their procedures to prevent the risk of suicide. Then over the page at 928, Lord Bingham addresses how to resolve this problem, that in some cases the system won't achieve compliance on behalf of the state. And he says that the answer at paragraph 35 is to reinterpret, using the Human Rights Act, the statutory provisions so as to mean so that the how question means not simply by what means, but by what means and in what circumstances. And then he goes on to say at paragraph 36 that where a simple choice between traditional short-form verdicts won't do the job, the coroner must return or elicit from a jury a narrative form of verdict, either in the form of either by the means of questions or by some other means. And he makes reference to some of the issues identified by statute under the Scottish legislation as helping to guide those questions. At paragraph 37, he says that nevertheless the existing statutory prohibitions on findings of criminal liability and so on must be respected. And at 37H, he suggests a sample verdict. The deceased took his own life in part because the risk of his doing so was not recognised and appropriate precautions were not taken to prevent him doing so, which he identifies as a judgmental conclusion of a factual nature directly relating to the circumstances of death. So whereas in Jameson he had said narratives should not be judgmental, shouldn't express a judgment, this one should express a judgment, could and should express a judgment, but should still do so in factual terms.
So which paragraph was that?
This is paragraph 37, 202H on MS 928. Now, since the Middleton case, it's been established that this reading of the how question and this approach to narrative verdicts only applies to cases where the Article 2 requirement for an independent state investigation is engaged. That's the Hurst case, which we cited in our case. In other cases, which are the majority, the Jameson approach continues to apply. As to when Article 2 is engaged in this sense, it's engaged normally when it's arguable that substantive duties under Article 2 were breached in relation to a death. So, for example, if it's arguable the Osmond duty has been breached because of failure by the police to take protective action. It's also engaged automatically in some classes of case, such as violent deaths in prison, because of the nature of the death. And the authorities establishing that are fully set out in the Letts case, which we cited and which is at Authorities 4, tab 56. As we saw, the Middleton approach was given statutory force by Section 5(2) of the Coroners and Justice Act. I think it's probably now appropriate for me to deal briefly with the Bubbins case.
But before we get to that, the Peirce case you mentioned is, what case, which is that?
Now, the Hurst case...
Oh, Hurst, I beg your pardon.
Hurst, Authorities 453. The start of the case is MS 1684.
Now that predates the current legislation.
It does.
So if under the current legislation the coroner is given a discretion to adopt the narrative form, for example, which is not restrained to issues where convention rights are engaged, then presumably, to that extent, the coroner presumably is entitled to do what the legislation tells him.
Well, yes, but what we would say is that the legislation was passed against the background of the existing case law. The existing case law interpreted the how question, which is cast in basically the same way in the 1988 Act and the 2009 Act. In both acts, the coroner is required to answer the question how the person came by their death. The Jameson and Middleton cases established that how question has a particular meaning. The how question means by what means in the majority of cases, it means by what means and in what circumstances in cases where Article 2 is engaged in the sense that I've identified. So when Parliament came to legislate by Section 5 and Section 10 of the 2009 Act, it wasn't scrapping that meaning of the how question. It was, as we saw by Section 5(2), giving it statutory force, saying...
Yes, but it's not restricted to cases where convention rights are engaged.
What isn't restricted, my lord? I'm sorry.
I picked you up as saying that Hurst effectively confined what coroners could do under the legislation. Legislation postdates Hurst, so I'd have thought the powers of coroners are nowadays defined by the legislation rather than by earlier cases.
They're defined by the legislation, but the legislation has been... Identical legislative provisions have been authoritatively construed by the courts. And what the Hurst case decided was that the reinterpretation of how, which was required by Middleton, was not required for cases where Article 2 is not engaged. And we can see that in Hurst.
Oh, I see. Well, I think we may be at cross purposes. Section 5.2 says, where necessary in order to avoid a breach of any convention rights, how effectively is to be read as including in what circumstances.
Yes.
Yes, that's fine. We've just been at cross purposes.
I'm sorry. The state of affairs, both before and after the 2009 Act, was that you have the majority of case inquests, which are dubbed Jameson inquests, where it means by what means, and then the minority, which are Middleton inquests, where it means by what means and in what circumstances. And they can have this longer, more judgmental form of narrative verdict.
But I mean, Section 5.3, in fact, confirms that by saying they can't express an opinion on anything else
Yes,
other than the Article 2 case.
yes,
That really confirms Hurst.
yes. Although Section 5.3 is following a statutory predecessor, which was introduced to prevent coroners and juries adding what we call riders to their verdicts.
But the sort of amendments were introduced a reference to the Article 2, which follows Middleton.
Yes, yes. So Section 5.2 gives statutory effect to Middleton. That was its purpose and effect. I was going, if it's convenient now, just to deal briefly with the Bubbins case, which I mentioned earlier during Ms. Monaghan's submissions. That's in your black afternoon file, Divider 5. And that was a case in which a young man had been shot during a police firearms operation. And one of the grounds of the claim was failure to comply with the Article 2 procedural obligation. We see that addressed by the court at page 486. Paragraph 153. Where the court begins by observing that an inquest can fulfil the Article 2 requirements of an effective investigation into alleged killing by state agents. And it refers to characteristics of the inquest procedure previously noted: public hearings conducted by independent judicial officers, normally sitting with a jury. And certainly in cases of alleged killing by state agents, coroners normally do sit with the jury. Judicial review lies. There are thus strong safeguards as to the lawfulness and propriety of the proceedings. There's a range of verdicts. One of those is what they describe as unlawful death. And although a coroner is required to confine his investigation to matters causative of the death, that doesn't prevent examination of broader matters such as the planning of operations and so on. And then page 488, paragraph 163, having considered the inquest in this case, the court observed that it was a substantial matter, and at the fourth line, although the coroner directed the jury to return a verdict of lawful death, so effectively withdrawing unlawful death, doesn't consider that this deprived the proceedings of their effectiveness if an independent judicial officer, such as a coroner, decides after an exhaustive public procedure that the evidence points to only one conclusion, does so subject to review, can't be maintained that this decision impairs the effectiveness of the procedure. And over the page at 165, therefore no violation of the Article 2 obligation. I appreciate that doesn't absolutely and directly answer my Lord's point, because it doesn't grapple with the standard of proof.
So what do we get out of it?
Well, you get out of it that generally inquests are capable of discharging the Article 2 obligation. You also get out of it that a coroner who has withdrawn unlawful killing, presumably on the basis of the criminal standard, is regarded as having discharged the obligation by his inquest. But it is, we suggest, not very surprising that the Strasbourg court hasn't been asked to grapple with something like standard of proof, because that is preeminently a matter for individual states and their investigation procedures. Now, turning to brass tacks, in inquests where Article 2 is not engaged, the coroner or jury normally answers the how question by a combination of, first of all, a sentence or two in box 3 of the form, and then choosing a short form conclusion for box 4, or alternatively, a brief and non-judgmental narrative. In cases where Article 2 is engaged, there will often be a modestly longer narrative conclusion, which may identify underlying and contributory causes of death, sometimes in judgmental terms, and that may be obtained by a set of questions, as happened in this case. My Lord saw the example of the form as completed in this case. The defining feature of inquest proceedings is that they're inquisitorial, and these rules and procedures have been developed accordingly. There is no equivalent to statements of case or indictment to prescribe a set of issues for resolution. The coroner determines the scope of inquiry, decides what inquiries to carry out, including seeking documents and having statements provided, and the coroner selects the witnesses to be called. At the inquest, the coroner calls each witness, and usually it is the coroner who asks questions first. His or her overriding responsibility is to carry out a sufficient inquiry to answer the statutory questions. The courts accord coroners a significant margin of judgment in deciding on scope of inquiry and evidence to be adduced. That's a short summary of what inquests are nowadays. Those points are well articulated in the judgment of Lord Burnett in the Hambleton case, for your note MS 1679, as a modern expression of Lord Lane's classic passage in Thompson, which was quoted in the courts below. So that's what I propose to say about the legal regime governing coroners. I was going to address the question of the note when it came to the substantive arguments, if that's convenient. May I then turn briefly to standards of proof in civil proceedings? My lords, as has been accepted, for most purposes, the standard of proof for issues of fact in civil proceedings is the balance of probabilities. That applies equally to a finding of fact that somebody intentionally killed him or herself. It applies to factual findings, which may indicate that a criminal offence has been committed. And I put it in those terms, of course, because in a civil action, what is found is a factual finding indicating that a criminal offence has been committed, rather than a finding of law that a criminal offence has been committed. Until the law was definitively clarified in the Re H case of 1995, there were various dicta in Hornell and Neuberger and Kawadja and other cases suggesting that the balance was weighted or tilted in cases where serious allegations were under consideration. That's the sliding scale approach, which is still favoured in some other jurisdictions. In the Re H case, Lord Nichols made clear that the balance of probabilities is a uniform standard, and it's not made more exacting because the issue concerns a serious allegation. That's the classic passage at page 586 of the Re H case, MS 985. I don't propose to go through it because I expect that it will be familiar reading. The Re B Children case of 2008 clarified the position further, and it did so in substance by rejecting the position that serious misconduct is always inherently improbable. It may be inherently improbable, it may not be. It may be obvious that there has been some serious misconduct. So, for example, in the care case where it is obvious that a child has been abused and the question is which parent is responsible. There, one is not assisted by saying that abuse is inherently improbable. It happened. Now, as the appellant has pointed out, there are some civil proceedings in which the criminal standard of proof has been adopted, notably in contempt, the contempt jurisdiction. And we would suggest that the law adopts this course in exceptional cases, having regard to two considerations. First of all, the seriousness of the consequences, and secondly, the subject matter, especially if a civil proceeding has a quasi-criminal character.
Well, certainly, contempt proceedings aren't really a very good example because they're often said to be sui generis.
Yes. May I go back, though, to the Maughan case, which you were shown briefly earlier, to make good the slightly broader proposition, which is at Authorities 60, MS 1827. Now there what was held was that the factual prerequisites for the making of an ASBO had to be proved to the criminal standard. Now you were shown part of what Lord Steyn said. If I can go back briefly to what he said, MS 1852, paragraph 37, letter G, he said that magistrates, when applying section 11A, concerning the factual prerequisites, should be directed to ask themselves whether they were sure the defendant had acted in an antisocial manner. And that was because they were to be directed to apply the criminal standard.
But if you look between E and F, he's saying, I agree that given the seriousness of matters involved, some reference to the heightened of the standard would usually be necessary. So this is one of the cases, well, he seems to be adhering to a superseded approach.
Well, first of all, and we can look at Re B. Lord Hoffman categorised the cases into three. He identified the cases where judges had got confused, cases where judges had applied a sliding scale, but also cases where judges had straightforwardly applied the criminal standard. And here, Lord Steyn is concluding not that a sliding scale approach should be applied, but that the criminal standard should be the direction. And it's Lord Hope then who agrees with that. And he does so in a more, possibly in a more intellectually pure way, at least in the form of expression, at MS 1866, page 826, where at paragraph 82, he records the submission of Mr. Crowe that the standard should be the civil standard, taking account of the improbability of an event. And then letter C says it's not an invariable rule that the lower standard of proof must be applied in civil proceedings. I think there are good reasons in the interest of fairness for applying the higher standard when allegations are made of criminal or quasi-criminal conduct, which if proved would have serious consequences for the person against whom they're made. And at letter G at the end of paragraph 83, I'd hold that the standard of proof that ought to be applied in these cases to allegations about the defendant's conduct is the criminal standard. So although there is some reference to the outmoded way of thinking in part of Lord Steyn's speech, the clear decision here is that the criminal standard applies.
Sorry, is Lord Hope in the majority on this?
Those were the two substantive judgments. They were both in the majority. If my Lord looks at the last page, 836, we can see that most readily that Lord Hobhouse agrees with Lord Steyn and Lord Hope. Lord Scott agrees with Lord Steyn, Lord Hope and Lord Hutton.
So where does that leave us?
It's page 8, sorry, it's MS 1876.
No, I mean, I take
page-
what you say. It seems to be a majority position, but it doesn't seem to fit in very well with the other cases.
Well, part of the problem is that cases concerning orders such as sex offender orders, football banning orders and ASBOs have been considered in some instances based upon the notion that one can have a sliding scale, a civil standard, which is indistinguishable from the criminal standard. It's not clear whether under the new approach, a court might say squarely the criminal standard should be the standard to apply. And of course, it's noteworthy that in the case of Birmingham City Council and Shafi, when the court had to decide whether a civil injunction with the same effect of an ASBO should be decided on the civil standard or the criminal standard, the court said it should be the criminal standard, because otherwise one would have the absurdity of an ASBO order, being made by the criminal standard, and an order under Section 222 of the Local Government Act, with exactly the same effect, made by a different standard.
Oh, sorry, where's the reference to that?
Shafi is Authorities 2, Divider 17. The finding that the same standard of proof should apply is MS 1067, paragraphs 52 to 53.
And this is the Supreme Court, is it?
That's the Court of Appeal saying that
Yes,
the effect of the McCann decision of the House of Lords.
I mean, I understand what it says. I just wanted to find it.
Yep.
There's a Court of Appeal following effectively the logic of the McCann case.
Yes. And even in the passage from passages from Braganza and Re B, which have been considered, there is a recognition that there are some civil proceedings in which the criminal standard of proof will be adopted. Lady Hale refers historically to matrimonial cases where there was an offender and the criminal standard of proof would be applied, obviously not appropriate to the modern era.
That's where the criminal law is engaged. Where it's an offender. I mean, I'm talking about an...
I think it was a quasi-criminal position, but I'll check that over.
Thank you.
But there are those cases, and they created something of a difficulty, such as B and the Chief Constable of Avon and the Goff case, which are cited in paragraph 45 of the appellant's case, where the courts have said that a civil standard indistinguishable from the criminal standard should be applied. And it's possible to say that nowadays a court would say that the civil standard should be applied simply, or that the court might look again and apply the criminal standard. But what should be drawn from all these cases is that there are rare situations where civil proceedings will adopt the criminal standard if the consequences and nature of the issues are peculiarly criminal.
The two dicta that we've been taken to, particularly Lord Bingham in the Avon case and Lord Steyn at paragraph 37 of McCann, are both cited by Lady Hale in Re B, in a judgment with which all the other members of the court agreed, as illustrating how matters had got worse since the sort of rot set in with the introduction of the idea of a sliding scale. And these passages are cited as examples of that error. You'll find them both cited in Re B at MS 957.
But if my lord then looks on to 958, paragraph 69, Lady Hale recognises there are some proceedings, though civil in form, whose nature is such that it's appropriate to apply the criminal standard of proof. And then she refers, as I said, to the olden days.
The old days of the matrimonial offence.
But care proceedings aren't of that nature. They're not penal. Consequences for the child of getting it wrong are equally serious either way. So even there, Lady Hale is recognising that there are some proceedings, I acknowledge rare, civil in form, which will attract the criminal standard of proof. May I then turn to the suicide conclusion in inquests? And that's a conclusion which has been used in coroners' courts for centuries. Until the 20th century, the standard of proof wasn't the primary focus of concern. As we've identified in our printed text, pages 12 to 14, the principal concern of the courts and the textbook writers was whether the evidence established a degree of mental incapacity which would lead a coroner or jury to conclude that the person had been of unsound or unbalanced mind, and so would avoid the felo de se verdict, which brought with it terrible penalties. Even after those penalties were abolished, the principal concern remained this question of mental capacity. There was then the series of cases from 1944 to 1975, cited in paragraph 30 of our case, which established that suicide, in particular suicidal intent, shouldn't be presumed and shouldn't be lightly inferred from the circumstances of death. We would stress 4 points about those cases. First, they all drew upon the approach taken to findings of suicide in civil cases, in particular the case of Southall and Cheshire County News. There's no suggestion that they are creating a special rule for suicide conclusions in inquests. Secondly, none of them, prior to the Evans case, directly addressed the standard of proof. Thirdly, the particular concern of the courts in all those cases was to take issue with coroners finding suicide because it was difficult positively to formulate another explanation. And that's a variant of the Sherlock Holmes fallacy we saw in the Popey M case. And fourthly, even in these cases, the courts were careful to point out that no fixed rule was being laid down preventing suicide being found on the basis of circumstantial evidence. I don't propose to take my lords through those cases, my lady through those cases, because as Lord Justice Davis said when dealing with them quite briefly in the Court of Appeal, they don't really advance the debate. Everyone agrees that suicide should not lightly be inferred from circumstantial evidence, nor indeed that just as any other conclusion in an inquest shouldn't be lightly inferred. There is, of course, a particular danger with suicide in inferring intent from circumstances and action rather than looking for specific evidence, but it doesn't mean that a special legal rule is required. Then from the mid-1980s, we saw first of all the Evans case and then the Gray case. My lords have already seen the Evans case. There's no reasoning for the reference, the very brief reference, that proof on the balance of probabilities is not good enough. It doesn't even say what the standard of proof should be. That was first said in the case of Ex parte Gray, which was not about suicide at all. I'd like to identify just one point from the Gray case, which is Authorities 1, Divider 4, MS 881. And that was a case concerned with a conclusion of unlawful killing that was returned on the basis of lack of care of a person while in police custody. And Lord Justice Watkins addressed the standard of proof issue at MS 891, page 477. The point I just wanted to draw to my lords and my ladies' attention is a point made by Lord Justice Leggett in the Divisional Court, which is that Lord Justice Watkins' analysis is heavily built upon Lord Widgery's reference to a stringent test in the Barber case, which is in the last sentence of the passage quoted just by letter F. I approached this case applying a stringent test and asking myself whether on the evidence which was given, any reasonable coroner could have reached the conclusion that the proper answer was suicide. We would simply echo Lord Justice Leggett's point that the Lord Chief Justice in Barber was very likely referring to stringency in terms of public law review rather than stringency in terms of the standard of proof or requirement of proof for inquests. The other point we would make, of course, is that there isn't, beyond the assertion, a great deal of reasoning in Lord Justice Watkins' judgment. The essential reasoning appears at letter D. Suicide is a drastic action which leaves in its wake serious social, economic and other consequences, and that must justify, or that must require, a higher standard of proof. But in fairness to Lord Justice Watkins, one point we do see at the following page, 478A, MS 892, is that he is not beguiled by sliding scales. He says that the standard should be left without any refined qualifications about setting a higher standard based on seriousness of allegation. We would also point out that, setting aside the Gray case, that there were 2 divisional court cases decided within 18 months of Ex parte Gray, which apparently favoured the criminal standard of proof without any apparent reference to either Ex parte Evans or Ex parte Gray. Those were Ex parte Armstrong at MS 1544 and Ex parte Hopper at MS 1400. But once again, neither of those cases provides any great analytical rigour in supporting the higher standard of proof applying. I simply draw them to my lords and my ladies' attention because Lord Justice Watkins was not the only judge who apparently drew from the earlier cases some indication that a higher standard of proof was needed. There then followed from the late 1980s until the last few years a series of cases before divisional courts and single judges which stated or assumed that the criminal standard of proof applies. We've cited them all at footnote 39 of our case, but they were mainly cases in which there was no argument on the point, with the exception of McKerbin, Kendall and Lagos. I'll deal with McKerbin in a moment in relation to unlawful killing. May I then turn to the unlawful killing conclusion? The short-form conclusion of unlawful killing in an inquest has a particular meaning, as everyone has agreed in their cases. It means that death was caused by the commission of a homicide offence, murder, manslaughter, or infanticide. It might also now embrace corporate homicide under the Corporate Homicide and Manslaughter Act, but we don't need to get into that. The conclusion has a significant history. Under the early colonial legislation, the coroner's jury could make a determination of unlawful killing, which would have the same effect as the preferment of a bill of indictment. It would name a perpetrator who would be committed for trial in a criminal court. May we briefly look at the 1887 Act on this point, which is Authorities Volume 2, Divider 9, MS 994, Section 4.3. And here we see in Section 4, in very condensed form, many of the provisions we've been looking at in the 2009 Act. Subsection 3 deals with conclusions from an inquest, requires the jury to set forth who the deceased was and how, when, and where the deceased came by his death. So far, so familiar. Then it goes on, and if he came by his death by murder or manslaughter, the person or persons, if any, whom the jury find to have been guilty of such murder or manslaughter, or being accessories before the fact. And then there's also the requirement, subsection 4, for the registration particulars. Now note that the section envisages the jury making a finding that the person was guilty of the offence, not merely that there was a case to answer. I stress that point because Inquest in their submissions cite a passage from Jarvis on coroners, which suggests that before 1977, juries addressing this question should have been applying a case to answer test because they were serving the function of a grand jury. But that's not what the section says. The section says that the jury would find a person guilty. It would be a positive finding of a criminal offence having been committed. Now, the effect of it, we see at MS 995, section 5.1, that the Inquisition would charge the person with the offence and the coroner would then issue a warrant for arrest or detention. I should add that infanticide was added as a further relevant offence after it had entered the statute book in 1922. Now, if the coroner's court returned a conclusion of unlawful killing in line with these provisions, an entirely different inquisition form would be used. It would be a form entitled Inquisition Charging an Offence. It was scheduled to the 1887 Act and to subsequent coroner's rules. And that is all, that history is all given in the Wilkinson case, MS 2005 at MS 2010 to 14. The indicting function of a coroner's court became less significant in 1926, when the Coroner's Amendment Act of that year required inquest to be suspended during criminal prosecutions. But it still continued, and indeed Lord Lucan was cited for murder by a coroner's jury in 1974. In 1977, after recommendations by the Wright and Broderick committees, the indicting function was finally removed by Section 56 of the Criminal Law Act 1977.
Are you saying Section 4.3 was then abrogated?
It was.
Very well. No, Section 56 of what?
Of the Criminal Law Act 1977. My Lord will see that at Authorities 2.12, divided 12, MS 1002, Section 56.1.
Yes.
So after that change, the next statutory rules of 1984, for the first time, included a short-form conclusion of unlawfully killed in the list within the standard inquisition form. It was added at that stage. The unlawful killing verdict didn't exist in terms before that stage because there was no longer a different inquisition form for cases of unlawful killing, the form which led to the indictment. Those 1984 rules also introduced the requirement that no verdict should be framed so as to appear to determine criminal liability of a named person or civil liability. That was Rule 42 of the Coroner's Rules, 1984. So in short, the unlawful killing conclusion has an unusual history, a unique history, which sets it apart from all the other conclusions in a coroner's court. As to the standard of proof for unlawful killing, we haven't been able to find any positive statement of the standard of proof applying to unlawful killing conclusions before 1977. The divisional court in the case of Wilkinson suggested that it was the criminal standard. What we would say is that it's likely that the criminal standard was applied since the 1887 Act, as we saw, required the jury to find guilt of a criminal offence. As we've seen, the case of Ex parte Gray in 1988 addressed the standard of proof for unlawful killing conclusions, and then that was taken up again in the important case of McKirbin. I know my lords and my lady have been taken to that. May I go briefly back to it? It's at Authorities 1 Divider 5, MS 895. that was a case of a person being restrained by the police and dying from asphyxia, a verdict of misadventure challenged, and one of the grounds being that the coroner had wrongly directed the jury to apply the criminal standard of proof. And what we see from MS 899 and following is that Lord Justice Wolfe, with whom the other members of the court agreed, surveyed the historical background to the unlawful killing conclusion. And at MS 900, 724E, he says that it considerable assistance was provided by the 1887 Act in considering the question of standard of proof, because of the significance of the verdict as a matter of its etiology. He then considered the standards of proof in civil and criminal proceedings, which were then governed by the cases of Horner and Kawaja. And that at MS 903, which is page 727, towards the bottom, letter H, Lord Justice Wolfe spoke about the potential attraction of applying a civil standard, but a very high civil standard, but then went on to say that because this had to be a matter for direction of juries, it should be the criminal standard to be applied. And then at 728, between C and E, he made clear the coroner should indicate to the jury they should approach the question as to whether or not they're satisfied, so that they're sure that this is unlawful killing. So, undoubtedly, Lord Justice Wolfe's thinking was influenced to an extent by the outmoded thinking of sliding scales for civil standards of proof. But he was also influenced by the history of the unlawful killing verdict and its significance as a criminal finding. Since the decision in McKirbin, there have been a series of cases in the Divisional Court and Court of Appeal endorsing the proposition that the criminal standard applies to the conclusion of unlawful killing. And they're set out in footnote 43 of our case. May I then turn to arguments for the civil standard of proof to apply to suicide findings? And this was the essential conclusion of the courts below. In our submission, there wasn't any bar to them taking that course, and we would say that the legislation does not mandate any particular standard of proof. Let me now deal with the point about the note. We agree that section 45, both because of subsections 1A, about regulating procedure, and 2A, about regulating evidence, was broad enough to allow the rulemaker to stipulate standards of proof. We also agree that it is possible for Parliament in a piece of legislation or a rulemaker to make an operative provision through a footnote, including a footnote to a form. It is simply a matter of statutory construction whether the rulemaker was intending to do just that. And we would make 3 points to suggest that the rulemaker in this case was not intending to stipulate a standard of proof in note 3 to the form. The first is that on its ordinary reading, the note is not phrased as stipulating or mandating something. It is phrased as explaining the legal position. worth bearing in mind that Note 3, of course, follows Notes 1 and 2. Notes 1 and 2 refer to what short-form conclusions or narratives may be adopted. So the starting point is giving guidance on some potential options for discharging the primary statutory duty to find how the person died. And then Note 3, we suggest, particularly when it's read against the background, as it must be, of decades of case law, is explaining an understood position. It is not phrased as laying down a new rule.
If it had been, it wouldn't have been in a footnote.
That's the second point I was going to make. The second point I was going to make requires a certain amount of common sense, but if the rule maker had not wanted to mandate particular standards of proof, that would surely have been done by an appropriate stipulation within the body of the rules.
Why do you say that?
Well, stipulating standards of proof for particular conclusions regulates how the jury or coroner is to do their primary task under section 10 of the Act. On a matter of such significance, we suggest that a sensible rulemaker would have spoken clearly within the body of the text, rather than providing some indistinct clue as to his or her intentions by a note to a form.
Well, there's nothing indistinct about it. It's perfectly clear. The only point is it's not in the body of the regulations.
Well, the point that I suggest is unclear about is that it doesn't read as mandating a new rule.
It could be, and I'm not expressing any view, that the words "the standard of proof required" means the standard of proof which is required under the general law, and for the short form conclusion, i.e. That would be consistent with its being in a note and not in an operative part of the Act. It's creating a rule.
I referred to the usual approach that one construes legislation against the background of case law. The rulemaker must be seen as preparing a set of notes which are of assistance to coroners and juries. In that context, it makes perfect sense that the rulemaker is seeking to provide a summary or digest of the existing case law by writing as he or she does.
In the preceding provisions, before you get to Note 2,
Sorry.
in the preceding provisions, before one arrives at Note 2, is there any mandatory requirement?
There is a mandatory requirement, as we saw in Rule 34, for this form to be
No,
used.
I'm talking about the section that's headed Form 2.
Oh. Well, this is the form which must be used to record the determinations.
For instance, the name of the deceased.
Well,
is that a mandatory requirement?
Well, Section 10 requires the jury to say who the deceased was, if they can. Now, it may not be possible to say who the deceased was.
So, I mean, that's a requirement that's there in the Act.
That's a requirement that's in the Act.
What about the medical cause of death?
Again, the coroner or jury must do that if possible, but there are some cases where the medical cause of death will be unascertained because medical science doesn't provide the answer. Okay. But I should add, as I said earlier, 2, 3 and 4 are all part of the how question.
We're told by Rule 34 that the jury must make a determination and any findings using Form 2.
Yes.
Now, how do we use Form 2 if they don't, if we don't treat Note 3 as the law? This is a bizarre argument. This is part of a statutory instrument.
Well, in respect, it seems to me a perfectly sensible. If I was drafting this, I certainly wouldn't have put such a fundamental thing as a standard of proof in a footnote like this. I mean, we seem to have completely different reactions to it with respect.
Yes.
I mean, we've got to try and make up our minds, but
Well, I can only provide the reaction which my client and I have.
yeah.
Yeah, well, let me put it this way. If we ignore footnote 3, on how then could the jury be said to be returning their verdict using Form 2?
I should add a further exercise at this point, which is that this form, when used by juries, is given to them without the notes as a matter of practice.
It may
Because
be.
it would be confusing to give them the full list of short form verdicts.
But that's nothing to the point. We don't give criminal juries criminal law textbooks. But we don't give them the Offences Against the Person Act, but it's nevertheless the law.
But it may be that on the true interpretation of the regulations, Form 2 doesn't include the notes. Notes are something else.
That's how it's read and given effect by coroners up and down the land, I have to say.
And it is headed notes, which might support an argument that it's intended to be for guidance and assistance, not declaring the law, as is normally the case with the legislation.
And in support of that, of course, the word notes follows the signature, which is the coroner or jury's endorsement of the findings that they have recorded using the form.
Yep. Yes, I see that.
Can you help me on this? I mean, one does need to understand what is meant by short form conclusions.
Yes.
If one's reading the notes. Where does one, and indeed what is meant by a narrative conclusion?
One only gets that from case law.
One only gets that
One only gets that from case law. Those are not terms defined in the legislation, which again further supports the idea that in order to read these notes, one is adopting a corpus of existing case law.
Yeah.
And the third point I was going to make, in addition to the points about the straight interpretation of the provision and the unlikelihood of standards of proof being mandated in such a footnote, is that as Lord Justice Davis pointed out, the argument is double-edged from the appellant's perspective, because the note says that the civil standard applies to all narrative conclusions without exception. And the point goes a little further. If my lords and my lady conclude, as pretty much everyone has so far, that it would be absurd to have a different standard applying to findings of suicide, whether couched in narrative or short form, then one can have regard to the interpretive device of construing against absurdity. If you follow this note in its absolutely literal form, as my Lord Reid pointed out forcefully to Ms. Maughan, then you are left with the conclusion which the appellant, both courts below, and pretty much everyone in this court so far has recognised would be absurd. Different standard applying depending on whether you express a finding of suicidal intent through a short form as opposed to a narrative.
In the Court of Appeal, this point was referred to, but they seem to have assumed that they weren't bound by the footnote.
We addressed it. I addressed it briefly. There wasn't such interest in the point. They had, I suspect, my Lord's reaction, as he put it to me, more readily and definitively than some have put it to me today.
And you say that's certainly the Chief Coroner's.
That is our position. Our position is that the note doesn't resolve this controversy. Let me turn now then to the main arguments in favour of the civil standard of proof applying to conclusions of suicide, whatever form they may take. And the first, which if my lords and my lady are following through our case, is paragraph 41 of our case, is that the virtue of this approach is that it avoids two anomalous results. First, it avoids this result of applying a different standard of proof depending on whether a suicide finding is in short form or in narrative form. Secondly, and critically, the approach of the courts below avoids the result that separate findings in a single narrative determination are reached by applying different standards of proof. Now, quite apart from the practical difficulties of directing juries, that would give rise to real objections of principle. Findings in a narrative about contributory causes of death may be dependent on findings about the intentions and acts of the deceased person. Applying different standards of proof to interdependent factual findings can result in a conclusion which is confusing, misleading, or unfair. And this case is a good example. It's why probably this case led to the problem being identified. In a case of apparent suicide in prison or in a mental hospital, there may be issues about whether the authorities should have foreseen and taken better precautions against the risk of suicide. Whether the deceased person actually intended to kill him or herself may obviously influence findings about such foresight and precautions. Equally, a finding that the person had a fixed determination to kill him or herself may be relevant to whether precautions would have made any difference. It would, we suggest, be illogical and arguably unfair to have these interdependent factual issues of suicidal intent, adequacy of precautions, and causation determined by different standards of proof and expressed in the same determination. Imagine directing the jury, and the fairness of directing a jury, by saying, in order to decide whether precautions were appropriate, you may need to consider whether the deceased person intended to kill him or herself, whether they had a suicidal mindset in the days leading up to death. You will have to think about that when determining whether the precautions were adequate. But then what does the coroner do? Does the coroner say, if you reach a view upon that, you have to apply the higher standard of proof, while applying the lower standard to the question of whether that suicidal intent should have been appreciated? Then when you turn to causation, obviously the fact that a person was fixedly determined to find a way to kill themselves may be highly factually relevant. Such a person might time the application of the ligature to make sure that they won't get caught by ordinary observations in the prison. So it may be important to consider that question. Again, is the jury asked to consider it but not express a view on it, or to consider it and apply a higher standard of proof than that applying to the interdependent question of causation? Second argument is that there are good reasons of principle for applying the civil standard, at least three of them. First, an inquest is an inquisitorial proceeding whose object is accurately to find and record the answers to factual questions. In that context, it's anomalous to weight the scales for or against particular factual findings. And I stress factual because unlawful killing may be different. Doing so only risks producing less accurate and complete factual conclusions. Secondly, one public good served by inquests is that they contribute to the reporting of deaths, making it more difficult for deaths by suicide to be found, risks underreporting of suicide as a cause of death. And that was specifically recognised as a matter of concern in the Fundamental Review of Death Certification. Thirdly, the criminal standard as applied in criminal courts and in some civil matters can usually be said to reflect the very serious potential consequence for an individual, and it reflects the public interest that a case must be proved to a high standard to justify a form of sanction or a finding of criminal liability. That is why it is called the criminal standard. Third argument, there are good reasons for applying the same standard to suicide in civil proceedings and in inquests. It's now well established that the civil standard of proof applies to findings of suicide in civil proceedings, and a judge's finding of suicidal intent in a civil case has the same capacity to cause distress to a bereaved family. Such a finding in a civil case may in fact result in more immediate and direct adverse economic consequences, as in disputes about life insurance. And there are therefore cogent reasons for applying no higher standard when one is looking at inquests. It's also notable that in the early cases in this jurisdiction, and in the cases elsewhere in the world, courts have generally attempted to align the approach in inquests with that in civil cases when concerned with suicide. The fourth argument is that, and we put it this way, adopting the civil standard would arguably aid compliance with the procedural obligation under Article 2 of the ECHR. In the Court of Appeal, Lord Justice Davis made the point that applying the civil standard to factual findings of suicide assisted compliance with the Article 2 procedural obligation. Now, we would acknowledge that the Article 2 case law doesn't mandate any particular standard of proof, but it does require resolution of the key factual issues in the case. That was that paragraph 20 in Lord Bingham's speech in Middleton. Applying a higher standard of proof to a finding of suicide increases the prospect of an open conclusion or a non-answer in a narrative. That may leave unresolved an issue, which on any view may be a key question of fact in a case. So while it can be said that the Article 2 procedural obligation requires an inquest to use the civil standard of proof, the use of that standard may help the inquest serve its function in the set of state procedures which should achieve compliance with the Article 2 obligation. And then finally, in relation to arguments for the civil standard to apply, it can be fairly argued that the reasoning given in the authorities which have favoured the criminal standard of proof is unconvincing, outdated, or both. As we have seen, first of all, the early cases adopting the criminal standard based themselves on a line of previous cases which had stressed that suicidal intent shouldn't be readily inferred from weak circumstantial evidence. But those earlier cases did not actually suggest the use of the criminal standard. A concern not to draw inferences from insubstantial material doesn't logically justify the choice of a higher standard of proof. In other words, imposing the higher standard of proof is an overcorrection or overreaction to the acknowledged problem. Secondly, it's been argued in places that the higher standard of proof is needed to simplify directions to juries. There are a number of answers to that. Most inquests concerning possible suicide are heard by coroners alone. Coroners' juries are asked to make other important and or distressing findings on the civil standard. Juries in civil cases use the civil standard of proof and would have to do so if they decided an issue of suicidal intent. And a direction to use the civil standard, but not to presume intent from action, not to infer intent from circumstances without a proper basis, is no more difficult a direction to a jury, than, in fact, a great deal easier than many they have to consider, such as directions on self-defence, directions on neglect, McNaughton directions on insanity, and so on. Thirdly, the most common argument for the higher standard of proof is that a public finding of suicidal intent can be distressing and stigmatising to the bereaved family. There are a few answers to this point. First, the same is true of findings in civil courts, but the concern about causing distress doesn't lead the law to weight the scales against a finding. Secondly, while not for a moment questioning the very deep distress felt by families such as the Maughans, it must be acknowledged that not all families feel the same. Suicide does not carry a universal shame or stigma in our society, thankfully. And for some families, it's more important that an inquest finding accurately reflects the loved one's state of desperation or the failure of public authorities to recognise and act upon clear suicidal intent. In the Lagos case, the claimant husband of the deceased was actively seeking a suicide conclusion which could not be returned because of the criminal standard of proof, although it could have been returned on the civil standard of proof. And finally, other findings made in inquests on the civil standard of proof may carry stigma or cause distress. There are adjectival findings of neglect, which signify a failure to provide basic care to a child or vulnerable adult. Such a finding can be very distressing for family carers. Narrative conclusions can include findings of fact suggesting failings by state or state agents and others to prevent a death. Again, they can cause real distress for caring professionals, for example. None of this causes the law to act by imposing higher standards of proof. So that's what I propose to say in defence of the position of the courts below. I do so, as I've said, not because that is the stance taken by the Chief Coroner, but in order to ensure that the court hears all the arguments. I stress that because the Chief Coroner would like it to be known by the Maughan family and by families like the Maughans that he is not favouring one side or other of this debate. And when I return tomorrow, I'll deal very briefly with some of the arguments on the other side, without, of course, covering ground which Ms Monaghan has most ably covered. I see we're approaching 4 o'clock, and that would be a convenient moment for me, if it would for my lords and my lady.
Yes, thank you very much. We'll adjourn then until 10:30 tomorrow.